Case 57, City of Burbank versus Lockheed Air Terminal. Again, we find ourselves at the Supreme Court of the United States. Facts. The City Council of Burbank adopted an ordinance that made it unlawful for a so-called pure jet aircraft to take off from the Hollywood Burbank Airport between 11 p.m. of one day and 7 a.m. of the next. It also made it unlawful for the operator of that airport to allow any such aircraft to take off from that airport during such periods. The only regularly scheduled flight affected by the ordinance was an intra-state flight of Pacific Southwest Airlines, originating in Oakland and departing from Hollywood Burbank Airport for San Diego every Sunday night at 11:30. Appellees sought an injunction against enforcement of a Burbank City ordinance, placing an 11 p.m. to 7 a.m. curfew on jet flights. The District Court found the ordinance unconstitutional on Supremacy Clause and Commerce Clause grounds, and the Court of Appeals affirmed based on the Supremacy Clause with respect to both preemption and conflict. What's the issue? Whether federal law preempted the local ordinance. The court affirmed, considering the pervasive nature of the scheme of federal regulation of aircraft noise, as reaffirmed and reinforced by the Noise Control Act of 1972, the FAA, now in conjunction with the Environmental Protection Agency, has full control over aircraft noise, preempting state and local control. Reasoning. The court noted that control of noise was deep-seated in the police power of the states. Yet the pervasive control vested in EPA and in FAA under the 1972 Act seemed to leave no room for local curfews or other local controls. What the ultimate remedy may be for aircraft noise, which plagues many communities and tens of thousands of people, is not known. The procedures under the 1972 Act are underway. In addition, the administrator has imposed a variety of regulations relating to takeoff and landing procedures and runway preferences. The court went on to say that the Federal Aviation Act requires a delicate balance between safety and efficiency and the protection of persons on the ground. Any regulations adopted by the administrator to control noise pollution must be consistent with the highest degree of safety. The interdependence of these factors requires a uniform and exclusive system of federal regulation if the congressional objectives underlying the Federal Aviation Act are to be fulfilled. If we were to uphold the Burbank Ordinance and a significant number of municipalities followed suit, it is obvious that fractionalized control of the timing of takeoffs and landings would severely limit the flexibility of FAA in controlling air traffic flow. The difficulties of scheduling flights to avoid congestion and the concomitant decrease in safety would be compounded. In 1960, FAA rejected a proposed restriction on jet operations at the Los Angeles airport between 10 p.m. and 7 a.m. because such restrictions could create critically serious problems to all air transportation patterns.